In a single court decision, GCM loses control of 6 companies. What does that trigger concretely in a cascade?
In a cascading series of events, it means that this judgment caused Greenfinch Capital Management to lose its entire board of directors and be replaced by a provisional administrator who, with this specific order, assumed complete and total control, but in return also all of the associated legal responsibility. In terms of the companies it manages, there is a highly detailed and specific operational framework. It's that the GPI, I served as the sole 100% shareholder of the GP. By losing control of the general partner, meaning myself, the general partner unfortunately triggered a catastrophic avalanche of extensive technical defaults regarding the various financial credit agreements they had previously entered into with the specific companies they managed. Because it was explicitly stipulated in the legal terms, if I were to lose control over that specific aspect, then you would have a significant technical default event in the credit agreements in place in all the companies they managed, which meant that the banks would immediately accelerate the repayment of all outstanding credits and had full access to all the liquidity in the accounts and could take them to repay the credits and even all future income. They had complete access to all of that, which meant that in a very short period of time, 4, 5, 6 weeks, all the companies they managed had no liquidity in their accounts because all the liquidity that was there or arriving was going to be paid directly into the credit agreements. The AED, the Registration Administration, got wind of this order and was afraid of all the consequences that could result from it and accelerated a VAT that is which we had been discussing since 2021, whether it was due or not due or to whom it was due. And they interpreted that the GP, all the companies it managed, would be jointly and severally liable. And that is exactly why they issued a formal demand for payment, sending the official value-added tax assessment statement to every one of these business entities, which subsequently triggered a full bankruptcy proceeding for all the companies with a single claim. Just imagine for a moment that you have an invoice that someone owes you, and you decide on your own to send it to 10 different people, and you try to force those 10 people to pay it. And since no one pays it, you put all 10 people into bankruptcy.
This order specifically targets companies in which Octogone has no interest, no stake, no economic link. What does that inspire in you?
It inspires me that if I read the order in detail, which we did later, we analyzed it with our lawyers. That is to say, this order had 280 pages and 2 pages of summary and conclusion from Octogone. Ultimately, this judge who made this decision understood absolutely nothing, not by any stretch of the imagination, but instead simply read and believed Octogone's conclusion. And that's what led to, in fact, this completely insane decision.
Even companies not directly targeted by the order were severely impacted by this decision. Can you tell us about the company Connection PD, developing the real estate project of the same name in Ham, which also found itself caught in the spiral?
The Connection project and the company were impacted indirectly because the parent company was affected by the provisional administrator. And that set off a massive and overwhelming avalanche of unforeseen consequences. Because the project financiers became deeply concerned and immediately initiated a complete and immediate suspension in funding for this entire project, until there was further clarification on this specific order.
The measures decided by the judge are presented in principle as precautionary measures intended to preserve first and foremost the interests of each of them. What failed, in your opinion?
The fundamental nature of the order, and specifically how it's written, is entirely contrary to what it's supposed to do. That means, as you just rightly said, it was originally there to preserve. But the order, so if you have even the slightest understanding of a fund system and a company and the intricate way in which it actually functions, the order is fundamentally contradictory to what it should do, which means to protect. And it's just that if you deprive a company of all its income, the outcome becomes very simple and clear to see. Revenue and expenses. If you have no more revenue and only expenses, well, you're going to go bankrupt. And the European average for a company that no longer has income is 28 days before it goes bankrupt. And on top of that, the provisional administrator, whose mission was to protect and preserve everything, and who should have been a professional in the field, It was up to him to go back to the judge and explain to them that her order was contradictory to what she wanted to achieve. But he chose the opposite. He ultimately chose to do absolutely nothing at all and wait for all the companies, naturally, to go bankrupt. Because that was the natural order of things. It had essentially been a systemic condemnation of systemic condemnation to go bankrupt.
In your opinion, what should the judge have done?
In our view, the presiding judge should never have made such a unilateral judgment of a regulated company of this size, especially regarding an investor who has exactly 800,000 euros invested. This amount represented only 0.4% of the total capital. Yet the decision could potentially penalize the remaining 99.6%, without the court even having heard what the opposing party, meaning us, had to say. And besides, if she had asked herself the right question, and indeed, if there were even the slightest bit of truth in all that, that means if 0.4% can ask for 168 million euros, the remaining 99.6% should ask me for 50 billion. That is to say, even at 168 million, with 800,000 euros invested, I would have made a return of 21,000%. With that, I would be the best fund manager in the world.
How much do you estimate the damages suffered as a result of this court decision? And what actions can still be taken to obtain compensation for it?
The damage is very difficult to calculate because we have the current damage, which is currently in 2024, it's approximately 1.4 billion. But you have the future damage, which is very difficult to calculate in the sense of how to estimate the damage when you've taken away the chance of the future. If there is only one method of calculation, it is to analyze the past and extrapolate it into the future. And that's how we're going to estimate the damage. And the damage will be calculated, it will double every 2 years. Our performance over the last 10 years of our fund, that means doubling our equity and our capital by 2 every 2 years. That is to say, every 2 years it doubles our damage. Today, 1.4, tomorrow 2.8, the day after tomorrow, 5.6, and so on. Which means that the amounts at stake are enormous. And today, here, there is only one person responsible. It's not Octagon. Octagon has the right to initiate a procedure and ask for whatever it wants. But the obligation to see if this is technically feasible and if it's normal, that's the justice system. And the justice system here, it has not done its duty. And that's why the one responsible for all this, it's the state. Because the justice system is the representative of the state, and that means we will hold the state accountable.